Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Jason Brisman, decided January 9, 2025. Troutman, J. The intermediate appellate courts are empowered to reduce a sentence that, though legal, is unduly harsh or severe. CPL 470.15, 6b. The decisions whether a sentence warrants reduction under that standard, and the extent to which the sentence should be reduced, are committed to the discretion of the intermediate appellate court, which has broad, plenary power to reduce the sentence, without deference to the sentencing court. People v. Delgado. A defendant need not demonstrate extraordinary circumstances or abuse of discretion by the sentencing court in order to obtain a sentence reduction. See People v. Brenda W.W. People v. Acosta. People v. Mitchell. While incarcerated for manslaughter, defendant engaged in a fight with another incarcerated person. Defendant cut his finger during the fight. His opponent sustained a face wound. After restraining the combatants, correction officers found a bloody, sharpened porcelain shard lying within an arm's length of defendant. Defendant was convicted of promoting prison contraband in the first degree, Penal Law Section 205.25, 2, and sentenced as a second felony offender to 3.5 to 7 years in prison. The Appellate Division rejected defendant's challenge to the severity of his sentence on the ground that there were no extraordinary circumstances or abuse of discretion warranting a reduction of the sentence in the interest of justice. Quoting People v. Planty. Although we lack the discretionary authority to review a challenge to the severity of a sentence, see People v. Spicer, we have the power to review the applicable standard. See Delgado. See generally People v. Gilotti. Because the Appellate Division applied an erroneous standard, we reverse the order and remit for consideration of defendant's excessive sentence claim under the proper standard. The Appellate Division has the inherent power to reduce an unduly harsh or severe sentence. People v. Thompson. Indeed, even before the 1896 establishment of the Appellate Division, the intermediate appellate courts had the power to reduce a sentence as excessive and severe. People v. Hildebrandt. See People v. Casey. Sentence challenged in the lower courts as excessive. See also People v. Miller. Reducing a sentence of imprisonment to a $25 fine. People v. Baldwin. Reversing dismissal of an appeal on the ground that the defendant had the right to have the Court of Sessions exercise its discretion as to the sentence. Over the years that followed, the legislature enacted statutes clarifying the Appellate Division's powers. The first instance of legislative action was in 1919, when the legislature formally codified the Appellate Division's complete jurisdiction to reduce the sentence. Spicer. This legislation came on the heels of two significant Appellate Division decisions. In People v. Miles, the Third Department granted a new trial as a remedy for an excessive sentence, and, in People v. Cerulli, a split Second Department called Miles into question. The 1919 legislation confirmed that the Appellate Division had the power to reduce sentences as the intermediate appellate courts had done before. New Yorkers enshrined this power in their Constitution. People v. Pollins. While the 1919 legislation settled any questions about the intermediate appellate court's broad powers and the proper remedies, it said nothing of the standard. Over the ensuing decades, however, appellate decisions confirmed the court's historic power to reduce a sentence that is excessive or unduly severe. See e.g. People v. Marsh. People v. Fisher. People v. Spagnolia. Courts also began to use the synonymous term unduly harsh. See People v. Gittelson. People v. McDonald. As one court observed, the Code of Criminal Procedure, which governed criminal procedure in this state through 1970, gave every defendant the right of review of the sentence meted out to them, and imposed upon the court the responsibility to determine whether the sentence is harsh and excessive and should be modified. People v. Corapi. At the same time, some appellate division decisions contemplated a heightened standard under which the defendant must demonstrate extraordinary circumstances or abuse or discretion. See e.g. People v. Caputo. the imposition of sentence is within the discretion and judgment of the sentencing court, and an appellate court will not interfere with such discretion except under most extraordinary circumstances which do not here exist. People v. Nixon. It cannot be said that the trial court abused its discretion in imposing the sentence it did. The legislature settled any doubts with the enactment of the Criminal Procedure Law, CPL, in 1970. CPL 470.15 and 470.20, which have remained unchanged since the statute's enactment, empower the intermediate appellate courts to modify, as a matter of discretion in the interest of justice, a sentence that, though legal, was unduly harsh or severe. CPL 470.15, 6b, and provide that, upon doing so, the court must itself impose some legally authorized lesser sentence. CPL 470.20, 6. An abuse of discretion standard is inconsistent with the CPL, which commits excessive sentence determinations purely to the appellate division's interest of justice jurisdiction. Appellate courts apply an abuse of discretion standard in reviewing rulings that are inherently unsusceptible to broad generalization and therefore unamenable to clear rules for lower courts. Where the law accordingly commits certain trial-level determinations to a court's discretion to begin with. See Matter of State of New York v. John S. Abuse of discretion is, for example, the standard appellate courts use in reviewing a challenge to the admission or exclusion of evidence at trial, and a reversal or modification based on such abuse of discretion is one made on the law. See People v. Mohini, People v. Singleton, People v. Salim. See also CPL 470.15, 4a. Challenges to the severity of a sentence are addressed not to the appellate court's power to modify on the law but are instead addressed purely to the court's interest of justice powers. See CPL 470.15, 6b, which are distinct from determinations made on the law. See CPL 470.15, 3a, c. Accordingly, we have been clear that those courts have broad, plenary power to reduce a sentence, without deference to the sentencing court, Delgado. Our dissenting colleagues do not say that abuse of discretion is the proper legal standard for evaluating a defendant's challenge to the severity of a sentence. Instead, they suggest that abuse of discretion is not a standard of review at all, but a manifestation of the appellate division's conclusion upon application of the proper legal standard, that being whether the sentence is unduly harsh or severe. Of course, abuse of discretion is a standard of review familiar to appellate jurists all over this country, including the justices of our state's appellate division. As those justices well know, it is an inquiry distinct from whether the appellate division should exercise its own discretion in the interest of justice. See People v. ZH. Although we do not conclude that the court abused its discretion in denying defendant youthful offender status, we choose to exercise our discretion in the interest of justice to determine that defendant is a youthful offender. We know the dissenters agree because we said as much 2 months ago. See People v. Shader. The dissent's misguided analysis flows from its misunderstanding of Delgado. In Delgado and its 2 companion cases, Diaz and Ramsey, we were presented with 3 decisions wherein the defendant's sentencing challenges split the appellate division. See People v. Delgado, People v. Diaz, People v. Ramsey. One majority memorandum concluded that the sentence was not excessive under the circumstances, and added that the court did not abuse its discretion. Diaz, and concurrences in the other 2 urged the application of an abuse of discretion standard. See Delgado, Ramsey. In affirming, we began with the appropriate standard, explaining that the intermediate appellate court has broad, plenary power to modify a sentence that is unduly harsh or severe under the circumstances, and that this sentence review power may be exercised, if the interest of justice warrants, without deference to the sentencing court, Delgado. Having articulated a standard of review entirely incompatible with an abuse of discretion standard, we nonetheless concluded that the appellate division did not misapprehend its power in these cases, inasmuch as we read the appellate division's statements that the sentencing courts did not abuse their discretion to mean that the appellate division did not find the sentences unduly harsh or severe under the circumstances. Our understanding that the appellate division did not find the sentences unduly harsh or severe under the circumstances essentially mirrored the conclusion in Diaz that the sentence was not excessive under the circumstances, language which is conspicuously absent from the decision below, obfuscating the distinction between Diaz and the instant case by describing their language as virtually identical. Moreover, our decision in Delgado was specific to the statements as we understood them in the context of those writings. We did not say that abuse of discretion is the appropriate standard, nor did we bind ourselves to affirming in every case where the appellate division employs abuse of discretion language. Indeed, the dissenters appear to agree that there are cases where the Third Department employed abuse of discretion language in applying the wrong standard of review, People v. Lancaster. Unlike in Delgado, we cannot read the references to extraordinary circumstances or abuse of discretion, in this case to mean that the appellate division applied the proper, unduly harsh or severe, standard because the Third Department's subsequent jurisprudence demonstrates, and indeed acknowledges, that it had not been applying the unduly harsh or severe standard at the time it decided the instant case. 6 months after deciding the instant case, the Third Department abandoned the extraordinary circumstances or abuse of discretion standard altogether. That court last articulated that standard in 5 decisions released May 19, 2022. See People v. Purdy, People v. Thompson, People v. Torres, People v. Blair, People v. Duckett. Only 2 weeks later, on the court's next decision release date, it reduced sentences in 2 criminal appeals. See People v. Harris, concluding that an aggregate sentence of 50 years to life for a persistent felony offender who was convicted of nonviolent felonies was unduly harsh and severe. People v. Drumgold, People v. Smith, upholding a sentence in a third appeal as not harsh and excessive. In one of those decisions, Drumgold, the Third Department reduced the defendant's aggregate sentence as excessive, even though the sentencing court did not abuse its discretion. The court later acknowledged this shift, explaining that its CPL 470.15(6)(b) jurisprudence had evolved past its old extraordinary circumstances or abuse of discretion standard. Brenda W.W. Interestingly, the dissent cites Harris and another sentence reduction 2 weeks thereafter, People v. Carrick, reducing a 20-year sentence to 12 years to rectify a disparity in sentencing of accomplices who received 5 years in prison and 6 months in jail, respectively, for the proposition that the appellate division is not imposing an improper barrier to relief. But one need only read the decisions to appreciate that the appellate division applied a different standard to the sentencing claim raised by this defendant than it did to those raised by the defendants in Harris, Drumgold, and Carrick, and that at least the defendant in Drumgold, if not the others, would have been entitled to no relief under the standard that the appellate division applied to the defendant in the instant case. The development of the Third Department's jurisprudence thus undermines the dissent's dismissive and regrettable assumption that our clarification of the proper standard is unlikely to have a significant impact. Our legal standards, and the words we use when articulating them, are of greater importance than my colleagues in the dissent suggest. The Third Department is to be commended for having led the charge in asserting the appellate division's discretionary sentencing powers in Miles and deserves great credit for its recent efforts to bring its jurisprudence back in line with the appellate division's historical powers. And it is not the only department to have repudiated the extraordinary circumstances or abuse of discretion standard. The Fourth Department has been emphatic that this standard is incorrect. See E.G. Acosta, People v. Curtis, and the other departments are in accord. In People v. Mitchell, the First Department reduced a defendant's multi-year prison sentence on a conviction that resulted from his attempt to buy necessities using a counterfeit $20 bill, without regard to the sentencing court's discretion or the dissent's protest that the mitigating circumstances relied on by the majority were all too ordinary. See People v. Walsh, reducing a sentence based on the defendant's age, poor health, and expressions of remorse, over the protest of a dissenting justice concerning the absence of extraordinary circumstances. The Second Department has likewise cited ordinary mitigating circumstances, mental illness and lack of prior criminal record, in reducing consecutive, maximum prison sentences as excessive. People v. D'Amelio. The upshot is that the unanimous rule in all 4 departments of the appellate division is that A criminal defendant need not show extraordinary circumstances or an abuse of discretion by the sentencing court in order to obtain a sentence reduction under CPL 470.15(6)(b). Acosta. In other words, if defendant's appeal were being decided today in any department of the appellate division, he would not be required to demonstrate either extraordinary circumstances or an abuse of discretion. Instead, the standard would be whether his sentence was unduly harsh or severe, a standard that may be met by a showing of ordinary mitigating circumstances. CPL 470.15(6)(b). In an apparent effort to defend an extraordinary circumstances standard, the dissent asserts that the sentence imposed by the court of first instance will normally be appropriate, and that excessive sentences are an extraordinary occurrence. The dissent fails to offer adequate empirical support for those assertions, and, even if they are true, the dissent's reasoning is beside the point. Even assuming excessive sentencing is extraordinary in occurrence, excessive sentencing may, as the appellate division has long recognized, occur under ordinary circumstances. See e.g. Mitchell, Miles. There is no basis in the Constitution, the statute, or the historic powers of the intermediate appellate courts to endorse an erroneous standard that has been roundly rejected by the appellate division. Doing so would result only in harmful consequences by potentially insulating excessive sentences from modification, for society derives no legitimate benefit from imprisoning a person for longer than is warranted. Here, because the appellate division applied an improper standard in rejecting defendant's challenge to the severity of his sentence, the matter should be remitted to that court for a determination whether defendant's sentence is unduly harsh or severe. See CPL 470.15(6)(b). See People v. Baugh. Accordingly, the order insofar as appealed from should be reversed and case remitted to the appellate division for further proceedings in accordance with this opinion. Order insofar as appealed from reversed and case remitted to the appellate division, 3rd Department, for further proceedings in accordance with the opinion herein. Opinion by Judge Troutman. Chief Judge Wilson and Judges Rivera and Halligan concur. Judge Canataro dissents and votes to affirm in an opinion, in which Judges Garcia and Singas concur. Decided January 9, 2025.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law